The Honorable Chief Justice and Associate Justices of the Supreme Court of California. Hear ye, hear ye, hear ye. The Honorable Supreme Court sitting en banc is now in session. Please be seated.
Good morning. Welcome to oral argument. I do understand that counsel has signed waiver stipulations that Justice Whittaker may participate here and decide the case based on the video. Thank you. Clerk may call the calendar.
Good morning. The Supreme Court of California hearing oral arguments in San Francisco on Thursday, October 6, 2016 at 9 o'clock a.m. Case number S226645, County of Los Angeles Board of Supervisors et al. Petitioners versus Superior Court of Los Angeles County respondent, ACLU of Southern California et al. Real parties and interests. For real party interests, Ms. Rochelle Wilcox. And for petitioners, Mr. Timothy T. Coates. Case number S224086, Cheryl McGill, plaintiff and respondent, versus Citibank, N.A., defendant and appellant. This case will be continued to December 2016 calendar.
Thank you. You may proceed.
Good morning, Your Honors, and may it please the Court. My name is Rochelle Wilcox, and I represent the ACLU of Southern California and Eric Previn. I've reserved 5 minutes for rebuttal. This Court recognized in People v. Sanohui, 28 Cal 4th 205, in interpreting the marital communications privilege, that the phrase "in the course of" is inherently ambiguous. Here, too, because "in the course of" it in Evidence Code Section 952 is inherently ambiguous, the Court must look beyond the statute's language to discern its meaning. As the legislative history shows at MJN 1283, in adopting Section 952, the legislature intended to protect the client's communications to the lawyer so that the client could be assured that they could relay all relevant information to the lawyer safely.
Counsel, I want to hear more about your statutory argument in a moment, but it would help if you could say a little bit about what the ACLU wants here, really. What is the information that is most valuable that it is trying to obtain?
Well, it wants the invoices with privileged information redacted. It wants, first, the total amounts at issue. It wants the information about what has been spent on a case, and that would be reflected in the invoices. It may also be reflected in other documents, but the county hasn't pointed to other documents that would be readily available to the ACLU. And as the waterkeepers indicated in their amicus brief, the county is actually withholding that information based on the Court of Appeals opinion.
You agree that some information on a typical billing record should be redacted. What information should be redacted?
The information that would reflect underlying privileged communications. For example, telephone conversation with client regarding X. That is not...
How about just telephone conversation with client?
Telephone conversation with client is not going to relay the substance of the communication. If there is some way in which that reflects strategy, then perhaps there would be an argument that that would be privileged and could be...
15 telephone conferences in 1 week.
I'm sorry, Your Honor?
How about if the records reflected that there were 15 telephone conferences between the client and counsel in a week?
For the most part, that is not going to reflect the type of privileged communications that the legislature intended to...
When we go to trial, the argument is made they must have been really worried about this. They were on the phone twice a day.
Perhaps, well, those kinds of implications that may be drawn from the communication are not what is protected by the attorney-client privilege.
No, but it gives you an opportunity to argue that if you are able to discover it.
It gives you an opportunity to argue it in the context of pending litigation, arguably, but if the county had a reason for arguing that those types of communications would reveal some kind of strategy, then it could argue for the redaction of that information.
But I would... How would the trial courts implement a rule that allows for redaction of attorney opinions or advice?
Well, the trial courts have been doing this for years in the context of fee motion jurisprudence. For years,
There's been a waiver, have there not, of the attorney-client privilege in order to determine the fee waiver. What about situations, following up on Justice Corrigan's question and a little bit with Justice Chin, is maybe there's a huge deposition or a deposition of a high-level witness, and then there's a flurry of telephone calls, and then you see that an expert was from the fee bill was contacted, and it indicates who the expert was and how long they consulted with that expert. Why isn't that all something that implicates and impacts trial strategy of the county?
Well, it may be, and in that case, the trial judge, who has been doing this for years in the context of fee motion jurisprudence, the trial judge is in the best position to evaluate the privilege issue and to determine whether or not those entries that may reflect a lot of hyperactivity at a particular time actually reflect the kind of strategy. But I would point the court to the record that we have and the information in the record that reveals, and I think it's at 694 to 695, and I'll double check that in a second, that reveals that most of the times the invoices contain very minimal privileged information, and they're readily...
The county here has given you some invoices, right, from the 3 non-pending cases, isn't that right?
That's correct, Your Honor.
I didn't see that in the record. It's not in the record.
I don't believe that it is in the record, Your Honor.
Can you comment at all about what you've learned from seeing those in terms of what you think is privileged and what is not? I mean, just in general terms. You don't have to obviously talk about the documents themselves. I think the difficulty here is that we have nothing in the record to go on in order to figure out. I mean, I think your general proposition, which, I mean, I think is unobjectionable, that people, that there should be disclosure up to the point that the privilege applies. I mean, but that just restates the problem. That doesn't provide us any solution. So the difficulty here is in figuring out what kinds of information fall in which bucket.
And
help us with that?
Absolutely, Your Honor. I would say that, I mean, there are two issues. One is, as the court pointed out, we did receive invoices related to completed litigation. And so all of these concerns about pending litigation really drop out when you consider that the rule that they're advocating for would apply across the board to both pending and completed cases. And their concerns do not apply as readily to completed cases where none of that, what they might characterize as strategy information, is really important or will matter much anymore.
Counsel, would it be fair to say that virtually all the answers you've given so far to a series of related questions here about what is privileged and what is not define the phrase in the Corsa, which appears in 952 and 954, as really meaning strategic value?
Well, no, I mean, certainly in Mitchell and in Costco, this court recognized that there may be some transmissions of information that reflect strategy and that they have to be protected because they reflect strategy. But there, it is because the lawyer is sending something or the client may be sending something for the purpose of advancing the litigation. In the course of...
In Costco, it was an opinion letter, and that is obviously privileged. What do we have here that is privileged?
Your Honor, it is our position, certainly, that the invoices, because they are not sent to further the purpose of the litigation itself, they are not sent...
So it's not like an opinion letter?
It's not like an opinion letter. An opinion letter is to advance the client's purpose in the litigation or the whatever the matter is that is being handled by the lawyer, to advance the client's purpose of progressing that forward, taking steps to relay information so that the lawyer has...
So it's your position that the redaction process will take care of anything that is privileged in the billing?
It is, Your Honor.
I guess...
Now, excuse me, just 1 minute. Is the state of the law clear enough for the trial court to do that, or do they need more guidance?
We think the state of the law is plenty clear for the trial court to do that. And the trial courts have been doing this for years in the context of fee motion jurisprudence. It is occasionally the case that an invoice will have to be heavily redacted because, for whatever reason, that lawyer reflects a lot of information in the invoice, but that is not often the case. And usually, and again is reflected in the invoices that are in the record at 694 to 695, the invoices contain very, very minimal information that might be considered privileged information. For the most part, they relay things that have already happened in the litigation.
But in fee motion jurisprudence, which you've relied now on several times, apart from the fact that the parties have put out their fee motion, that's after the litigation, is it not? Already now we know what the strategy was, what the tactic is, and now it's about paying up and what it's worth. But it seems to me in your request, if this is correct, I believe that the reason the public records request was made is to determine the county's strategy and tactics and whether or not it was a scorched earth litigation. Isn't that what you asked for? You didn't ask for amounts that showed something. You're looking for amounts, as admitted, to look at a tactic the county was using. Am I incorrect in that?
Well, I think strategy and tactics have to be viewed in two different ways. I don't know that the county adopted a tactic of we're going to engage in scorched earth litigation.
Aren't you trying to find that out?
But
let me just answer that question. Is that why you said you asked for this public record request, is to determine whether or not the county was using a tactic of scorched earth?
Whether or not what the county was doing could be equated with scorched earth litigation. Yes, Your Honor, but I would clarify that doesn't make it a communication. The statute protects confidential communications.
But isn't what you asked for, the invoices, meant so you could glean the tactic? That's why you want the invoices, so you can glean and determine from that tactic, so you can basically take the invoice and deconstruct it to say this is what they're doing by way of strategy. I'm just asking if that's why in fact you made this type of request.
That is certainly one reason. We want to understand whether or not the case has been overworked. In the same way, a trial court will look through fee motion invoices that is submitted and evaluates whether or not there's duplication, whether or not there's
After the fact.
After the fact.
When you say
I would
this, the statute, which we are grappling with here, actually defines confidential communication. And it defines it as information transmitted between a client and the lawyer, so far so good, in the course of the relationship, and the relationship is here ongoing, and in confidence, and then so far as it's not being disclosed to anybody else, that is reasonably necessary for that the disclosure is reasonably necessary for the transmission of the information. The lawyers do have to get paid, and you're not arguing against that position, I'm sure.
That's
as
correct, Your
counsel.
Honor.
Or for the accomplishment of the person for which the lawyer is consulted, and it includes, but nowhere in the statute is limited to, a legal opinion formed and the advice given by the lawyer in the course of that relationship. So are you hanging your hat on that inclusion phrase to get to where you need to go?
Well, actually, two things, Your Honor.
Okay.
In the course of, and we think that the reason we submitted the extensive legislative history is because we think Chief Justice George was correct when he said in his concurrence in Costco that in the course of is intended to pull in all of the existing law.
You are mindful that no one joined Chief Justice George in that concurring opinion.
I did recognize
so
that.
So you are urging us now, as a newly reconstituted court, to join him in that view.
I am, and I would point out that, as far as I can tell, the legislative history was not before the court in Costco. And so the court didn't have the benefit of what we've provided in this case to make clear that in the course of was intended to imbue meaning beyond just during or while.
About that legislative history, counsel.
I'm sorry?
Say more about that legislative history.
So if you look at pages 1283 and 1285 of the legislative history, it's clear that the legislature was adopting the rule as it previously existed, and it specifically approved a series of cases that recognize that there has to be more than just a confidential communication between lawyer and client. It also has to be for the purpose of for why the lawyer was retained.
What you're suggesting is that the statute incorporates the privilege. The privilege does not protect every single communication that the lawyer and client want to keep private simply because they want to keep it private.
That is absolutely correct. And if the court looks at, for example, McNew, a case from this court, 23 Cal 2nd at 64, that was a case in which there was unequivocally a lawyer-client relationship. The client took the lawyer to a bank because he wanted the lawyer to be a witness about money that the client held at the bank.
But that's not the situation we have here. I don't think we quarrel that when a lawyer acts in a different related professional capacity where there is no attorney-client privilege, that everything that the lawyer happens to do with the person is privileged. We're really talking about a narrow issue here. And to me, when we look at the language of the statute of the definition of confidential communication, I'm interested in the last phrase that says, and includes a legal opinion formed and the advice given by the lawyer in the course of that relationship. So it says includes. And so there are other things, obviously, that are included in that, and it sounds expansive, and I don't read a limitation in there. So could you speak to the language of the statute and vis-a-vis what we said in Costco, which is it's the transmission in the course of an attorney-client relationship that's meant to be confidential, not shared with third parties, to protect the relationship that occurs between an attorney and a client.
But this is the second point that Justice Corrigan asked about. We think that includes also provides a limit. It's not limited to attorney advice and opinions.
And your general rule of interpretation that says includes is a limiting factor?
Well, it provides a limit under the doctrine of adjusdem, the doctrine of these things have to be similar. The county is rejecting that doctrine. It's arguing that doctrine doesn't apply here, but that when the statute is ambiguous, that's certainly one method for the court to interpret the statute. And we think under People v. Sonohui, it's clear that the statute is ambiguous. Invoices are not similar to attorney advice and opinions.
Could I ask you kind of your bottom line in terms of where you began your argument this morning? You said you wanted to know how much the county has spent on these suits. Is there anything else you want to know other than the bottom line figure?
We certainly want to know details about spending along the way.
What details?
We think it is important for the public to know if a case is hemorrhaging money. We think there's value in the public knowing what's going on so that they can go talk to the Board of Supervisors.
Beyond what the bottom line figure is?
Beyond the bottom line figure. We also think there is value and
value in the public knowing that X amount of money was spent writing this brief, X amount of money was spent doing this deposition, X amount of money was spent defending against this motion.
If a lawyer spent 100 hours on a 5-page motion that was flatly rejected, the public should know that so that it can circle back to the Board of Supervisors and say, what are you doing here? Why aren't you overseeing what's going on with your lawyers? There is, it's not just the LA County, it's other agencies, of course, across the state. We have to assume that there may sometimes be a cozy relationship between inside counsel and outside counsel, and that the public...
So for pending legislation like these 6 cases for invoices that the county declined, you want information mid-litigation in order to shape the county's litigation. Because if you received an invoice that said 100 hours on a 5-page brief, then in mid-litigation you would take that information and go to the county and demand that the litigation strategy be changed.
Well, that may be one circumstance, Your Honor. I would point out
versus waiting for a fee waiver and saying county should not have to bear the cost of paying 100 hours of the partner's fee for a 5-page brief. And so, Judge, you should cut that to $350 versus $200,000.
Well, I would point out, Your Honor, that in that circumstance, it's not clear that the public is going to be able to advocate for its position in the way it needs to be able to. The LA Times amicus brief made reference to a CPUC, a proceeding between the CPUC and the PG&E, where it was there was too cozy of a relationship. And one of the things that happened is the public went to a legislator and pushed for legislation to control the costs on defense spending, spending for the attorneys who would be hired to represent the CPUC commissioners, or it's somebody within the CPUC. There are circumstances.
I guess I could see this argument on two aspects. One is knowing the bottom line amount. Okay, that's like a kind of public fiscal accountability aspect. Knowing the bottom line amount, and secondly, that the litigation not be pending, that it be over. But it seems that anything beyond that, as the Chief Justice's question I think connotes, is an interference in the confidential relationship between the attorney and the client. And it isn't, the language is, I think, interpretable. I don't think it solves what we have before us. We're debating, lots of things that are left open by the ambiguous language. It just seems that if the privilege is really about protecting a sense of confidentiality between the client and the attorney, what you are suggesting is a direct invasion of that relationship.
Well, I would make 2 points, Your Honor. First, if it's privileged, then the pending litigation exemption in the CPRA is designed to protect those very interests. And so that is resolved to the extent that the courts and legislature have deemed it appropriate, by the pending litigation exemption. Now, the courts have held that it doesn't prohibit the release of invoices, and that the CPRA and the requirement for public access is so important that that information has to be released because it wasn't made for the dominant purpose of use in the litigation. But to the extent that there is a concern about that, that's really addressed in a different exemption that isn't at issue here. Here, the question is both pending and completed litigation, and that's why the concern is that the rule they're advocating is too broad, because it would keep us from ever being able to go back and get the invoices from even completed litigation, because they would not have an obligation to waive their privilege. If the privilege exists, then it doesn't end when the case is over.
So you would be happy with a rule that applied only to ended litigation?
Your Honor, we think that even as to pending litigation, we should get invoice details as well. We think that there is
What is your response to the Chief Justice's concern about pending litigation and interfering with the attorney-client relationship?
You mean the ability of the public to use that information to interfere with the attorney-client? They wouldn't be interfering directly with the attorney-client relationship. They would be actively, proactively
would
interacting
be able to use the strategy that the parties are using in that litigation.
To the extent that strategy is revealed, we concede that there may be information that would have to be redacted. We have always conceded that. And it could be that an invoice would have to be heavily redacted.
But the question is what information would be left. Let me just follow up on Justice Chin's and Justice Liu's question in a slightly different way. Suppose we were to agree that the fiscal accountability type interest might underscore why information about the total amount of billing might be quite relevant here, very much in the heartland of what the CPRA was aiming to cover. Suppose we agree also that information, that aggregate information, maybe is not so close to what the statute covers in terms of what's privileged. But then outside of the context of that aggregate information for overall billing and, focusing for a moment on litigation that is currently pending, what do you think is left that falls out of the privilege that you would still be able to get?
Well, and that's why I point the court to the invoices that are actually in the record. There's a series of invoices from county council, and I'm going to double-check the record site, but they show there were something like 30, 40 pages of invoices, 10 entries per line.
And what's on there that you think is not privileged is what?
Prepare motion for summary judgment. That has actually been filed. There may be 10 entries on a single line associated with preparing a motion for summary judgment. Once that motion is filed, the fact that somebody spent 50 hours on it is not revealing any kind of strategy. You can look at the motion and discern that kind of thing. What we're looking for are indicia, there are For the most part, while this case arose in the context of pending litigation, most of what people are going to be looking for is completed cases. And so most of what is there is not going to be redactable.
I just ask you, though, I want to be clear on what the dispute is about in this case. Isn't this case about pending cases?
It is correct that this case arose in the context of pending litigation.
All we need to decide.
But yes and no, Your Honor. The fact is that if the court concludes that they are protected by the attorney-client privilege, that privilege will go far beyond the facts of this case, and it will prevent people from getting—
May or may not, depending on how the interest behind the privilege is stated. I mean, I think, without prejudging the issue, I think it is plausible to make a distinction between pending and ended litigation. So I just want to be clear I know you think the logic sweeps more broadly, but the actual dispute here concerns pending cases.
And so I think that the attorney-client privilege, as it has consistently been interpreted, has not had a time limit. And that's why the pending litigation exemption is really the exemption that addresses the issue the court is focused on.
Can you say a little bit more about how that exemption works? What's the scope of that exemption?
The pending litigation exemption? Documents are exempt. It's literally pending litigation, and documents are exempt from disclosure under the Public Records Act if they are prepared for use in the litigation.
But it doesn't apply to billing records.
It does not. Cases have concluded that in Anderson-Barker, the court concluded that it doesn't apply to billing records. And
I understand your point that it's relevant in the larger scheme of things, but it's not particularly relevant to this dispute because it doesn't apply to the kind of document that this case is about.
That is an interpretation that, this is, of course, a CPRA case, and that is the interpretation that the court has given to the pending litigation exemption, keeping in mind the concerns of the CPRA. And, I don't want to lose sight of the fact that the Constitution does require a narrowing.
Can you tell me how significant a problem this is? After this litigation, are attorneys still including in their bills information regarding confidential information with the client?
That is not reflected in the record. What we do have in the record, Your Honor,
a client wants to know why they're being billed, right? A client questions the bill. A client says 100 hours for a 5-page brief? What? So I think it's a little disingenuous to say, well, I don't think that information is necessarily in the fee bill, is it?
And perhaps I didn't understand the point. Certainly, the client wants to know what they're being billed for. My point is that so much of what is revealed will already have been disclosed in the context of litigation. I want to, if I can, I know my time is getting short, I'd like to point the court to the decision in Salone, 39 Cal 2nd at 79 to 80, where the court actually drew the line between particular communications in the context of an attorney-client communication. And just focus the court again, if I can, on the purpose of the attorney-client privilege as enacted by the legislature. And certainly the court has interpreted that in a way that protects all communications that are designed for the purpose of giving or receiving legal services or advice, but it's never been interpreted to extend to something like an invoice, which is substantively different because it is sent for the purpose of getting paid and not for the purpose of advancing the litigation. A case can proceed without an invoice ever being sent. And so it's the lawyer's purpose of getting paid in a contract relationship between the lawyer and the client.
Are you saying that the reasonable expectation that a lawyer be paid is not part of advancing the litigation? That's an interesting position to take. Many lawyers would be amazed.
And that is, my point is a different point. For the purpose of the litigation, as contemplated by the legislature, as evidenced by the cases that we've cited in the brief, indicates that it has to be for the purpose of moving forward that particular transaction, of actually doing something to further the client's interest in that particular transaction.
Won't be furthered if they can't get a lawyer to take their case, and it is certainly true that there are wonderful lawyers who work for free. They are, generally speaking, not the vast majority of lawyers in all cases, and certainly not this kind of case.
But that you are with respect, Your Honor, you're conflating the purpose of the litigation with the purpose of sending the bills. And the bills, and I respect that I probably don't win you on that one, but the purpose of sending the bills is the lawyer's purpose, not the client's purpose for directly moving forward the case. Two more points on the CPRA before I sit down. In the CPRA context, the requester's purpose for seeking public records is irrelevant. So the fact that we may be looking to double check what the county has done is not relevant to the question of whether or not we're entitled to bills, and that's under Government Code 6257.5. Looking again at Delger and at McNew, 23 Cal 2nd at 63, the court really did focus on the purpose of the particular communication, and that's what the court needs to focus on here.
Thank you, Ms. Wilcox. You'll have 2 minutes on rebuttal.
May it please the Court, Timothy Coates on behalf of Los Angeles County Board of Supervisors and the Office of County Counsel. I think that real parties in interest here are giving the notion of a communication between an attorney and a client a very narrow definition. That in the modern world, and I think for all times, part of the communication and the central part of the relationship is advising the client what's going on in the case. And that doesn't occur just by sending them an opinion letter. It occurs when you advise them what the litigation is costing and what you are doing.
Counsel, is any information on a billing record unprivileged from your perspective?
I don't think so, because they are essentially status reports, albeit in a different form. You tell me what someone's spending on a litigation, and I get an idea of what they value, and I get an insight into their tactics. And that's true even if it's just an amount.
Even the aggregate amount at the very end, not
even
the line
the
items.
aggregate amount of the very end.
Okay.
And
how about the date?
I'm sorry?
The date?
In a pending litigation, it might, because probably you could, I imagine, redact a document so that it's completely useless. But I'm talking about what we're talking about here, financial information and or billing entries. And I think what's revealing...
Is your rule limited to pending litigation? Or is
no,
there...
it is not,
okay.
Because the attorney-client privilege is not limited to pending litigation. I will say, though, that I think what we have here, because it's sought in pending litigation, reveals why these kind of communications are confidential, because they do, in fact, reflect strategy. They do, in fact, convey information to the client concerning the attorney-client relationship, the litigation for which the attorney has been retained.
Why did the county then produce the invoices in the 3 completed cases?
Because the county, as a matter of public service, will waive the privilege at time and disclose what it's done. It will do that in the interest of public disclosure. And as in any case, the client always holds the privilege and is always able to do that. In the fee cases, that's what clients do.
So just following up on that, when the county did disclose those records, it redacted some of those records. On what was the decision rule to redact some things and not redact other things? What made that difference?
Not having been involved in this case, but having involved in many, many cases. I have done cases where we've redacted virtually everything except the amount. And then I've had a response from someone seeking those records. Hey, what did you redact? Beyond that, we're entitled to find out things like you prepared a motion for summary judgment. And I have to point something out here. My colleague across the aisle here has said that kind of information wouldn't be privileged because you've already prepared that. That's a matter of public record. That's not how the attorney-client privilege works. If I send my client a status letter listing, we've done the following things, plaintiff has scheduled a deposition. Okay. Now, the plaintiff's attorney knows they've scheduled that deposition. That doesn't make that communication any less privileged. They can't get that information from that communication. So they have a very narrow reading of what constitutes privileged information. It is not, and this Court has never held, just a legal opinion or just advice. It includes factual material that relates to that representation. And bills are loaded with that sort of information. In fact, that's what clients expect to see in it. Some of it are tasks. Some of it are the underlying amounts. From both, you can glean insight into the other party's strategic approach to a case. That's why I think it's kind of a textbook attorney-client communication.
Even though you were not involved in the redaction process of the records that were turned over, you can tell us what was used to decide what to redact and what to leave in.
In many cases that I've seen when the county's doing this and is waiving the privilege in the interest of disclosure, they might say something like, okay, prepared motion for summary judgment. They might take out opinion letter RE and not put in what the opinion is. I can't speak with respect to this case. I represent public entities in other cases. They are all over the map in terms of the amount.
And tell me what is wrong with that process.
With the county, there's no problem with the county deciding after the fact to do it. Any client can decide to waive the privilege for any reason. So, yeah, in that context, the county's doing the redacting. What they're talking about is, okay, you're going to do the redacting first, but we might contest it. Go in front of a judge. Now you have the very problem that Costco talks about, which is, well, then you have to have the judge looking at the actual record to determine whether it's been properly redacted or not. And that's forbidden by Evidence Code Section 915. That's why Costco really controls here. And I do have to say something about Chief Justice George's concurring opinion in Costco. As Justice Corrigan noted, is not the majority opinion. But they're also trying to get way too much out of it, because all Chief Justice George said in his concurring opinion was, we have to be mindful of what we've always said, that it has to be made in the attorney-client relationship, in furtherance of that. In other words, you've retained this person as an attorney. You haven't retained them as a broker. You haven't retained them, as the case that my colleague across the aisle cited, as someone to be a witness for some other transaction. There is no dispute here that the records involve services, attorney-client, in litigation. There's no dispute
Your
about
position is not so broad as to say that any communication traded between a lawyer and a client is covered by the privilege, because the lawyer, in some sense, in some context, may not be acting as the lawyer,
Correct.
but as something else. That's not an issue.
That's black-letter law.
Let me ask you something from a public policy perspective, since we're trying to interpret these, ambiguous statutes. Does your position essentially mean that there is no, required, other than a waiver situation, there's no required public accountability for what public legal departments do?
Well, there may be general accountability, lobbying your people, looking at general legal budgets, and look at the general expenditure for defenses. The county releases that.
Budgets, meaning...
Sheriff's Department spends $2 million a year on litigation. I don't know that that's the fact, but that's the kind of documents that they will give you aggregate amounts. I mean, that's...
Nothing that's case-specific, then.
They generally won't do case-specific unless, in some closed cases, they will in the public
interest.
interest.
Is that your position, that all the public can ever force the county to divulge is sort of what is a line item on a general budget?
Well, any place the information about what the attorneys are being paid is held in a non-privileged area, outside the context of communications from the lawyer to the client. There may be...
But I mean, your position would seem to imply that the public could never force through a Public Records Act request, could never learn how much was spent on a particular case or a particular matter. Is that your position?
If the only place where that information can be gleaned is by producing the invoices, if it's not otherwise disseminated, created, set out separately, then no.
Well, where else would it be otherwise available?
Well, you would find on a specific case basis, it might not be available on a specific case basis. It might be in an aggregate budget.
But supposing it is not available in the aggregate budget, supposing that a jurisdiction understandably enough chooses not to say, for example, of the $2 million a year litigation budget, $1.95 million is for this case, and the only way to get it is through a Public Records Act request. The answer, under your interpretation, is that information would not be public.
Correct. If the only way they can get it is by looking at invoices that are attorney-client communications, that's it.
How does that further in terms of, we were talking a minute ago about tactics, and I can see your point about anything in a billing record reveals what's important in relative amounts, right? But if you're talking about aggregate amounts spent on a case, that doesn't reveal that information, does it? It just means that the county decided to, spend a lot of money or a little money on whatever the matter was. But it doesn't reveal what happened inside the case.
Well, that's why the county generally, at the end, releases aggregate budgets.
But I'm wondering
what they
if it's
don't
protected
tell
by the privilege, though.
But what they want is a specific communication by communication. That's what they want.
No, I know, but I'm asking you a different question. I just want to know whether you think that is covered by the privilege, the aggregate amount spent on a particular case.
If it's if it's not from if it's not the invoice itself, not necessarily. It depends on where they keep it.
What does it matter?
Well, it matters because it's like you can often get privileged information from your attorney. You may disseminate it as a corporation and use it at other places in your corporation, and the rules of privilege talk about that.
But you're talking about a waiver. Where the entity decides to release it through another means, that's a waiver.
Correct, but that's
right.
how.
But I'm asking you a different question. Forget about a waiver. I want to know whether the aggregate amount is covered by the privilege, because it doesn't seem to imply the insight into tactics or what's important in the case. It just means that the county decided to spend $2 million, $1 million, $500,000, whatever the amount is, on a particular matter.
I think my point is, if the aggregate amount, if we're talking about it being on an invoice, the invoice is going to be privileged because you look to see what the communication is. What you're asking is it kept, if it's kept in another way, at least this is how I hear it, because I know the way public entities keep records.
The way it's kept is on that invoice, and you redact everything on the invoice except the bottom line figure.
Because it's still telling you what's being spent on the case. And it's telling you, in budget-wise, the case is worth this amount, at least worth this amount, because we're willing to spend this amount.
What does that reveal that is confidential, or what is,
well, again,
how does that map onto the purposes of the
two things. Again, factual information about the progress of a litigation, I think that's dead center of the privilege. It's true, this Court has said that factual information conveyed in the context of a case is privileged. It doesn't have to be advice. This is factual information about a case.
But a moment ago, I thought I heard you saying something different, so I want to give you a chance to distinguish two possible things that I think I've heard both. Yeah. One is the aggregate information, as Justice Liu was asking, may not be privileged under your account if it's not in a billing record, because the billing record is privileged. The other thing I'm hearing you say is it might be that the aggregate information is privileged even if it's not in the record.
If it's in
not in the billing record.
If it's in the billing record, because that's
so if it's in the billing record,
I took was that if the billing record has a running total, if you can get it from that's how I understood the question.
Right. So imagine, like, here's the billing record, right? We've blacked out everything except that last item, and if there's no other place to get that information, the question is that still privileged?
That's still privileged.
Well, so here's the challenge I have with that, just briefly, and that is in CBS v. Block, we talked about how the Public Records Act is best understood to not allow the failure to disclose every little piece of information simply because the rest of the record is all privileged. So it seems strange to me that simply because it's in a billing record, what would otherwise be available under your theory would not be available.
The reason why is because it's a communication coming from an attorney in a document that contains attorney-client privileged communication. Under the Costco case, and Costco says, the problem you have in this circumstance, the entire document is privileged. You don't get to pick and choose.
But Costco also said, if I recall correctly, that a lawyer cannot make unprivileged information privileged simply by putting it into a communication.
Correct. But you can't get that unprivileged information from the communication. That's the trick there.
So help me reconcile that with this provision of the PRA that I'll just quote now. Any reasonably segregable portion of a record shall be available for inspection by any person requesting the record after deletion of the portions that are exempted by law.
Because the problem you run into, and again, the PRA expressly incorporates the evidence code, you run into the Costco problem, which is the entire communication is privileged. You don't interlineate, okay? So that doesn't work with an attorney-client privileged communication because the entire document is privileged. It is not segregable.
So let me say, I understand your argument. Here's
Correct.
the PRA. Everyone has access, broadly construed. But the PRA has exemptions. Attorney-client is one of those. And so these other provisions that interpret the PRA and what you release and what you redact and what's confidential doesn't necessarily map on or apply to the attorney-client privilege. When we look at the attorney-client privilege exemption in the PRA, we look to confidential communication in the evidence code, which is described and been interpreted. But what I want to ask you is this. This case, I'm not talking about the case where you already gave up the invoices on 3 completed cases. The very difficult issue, this is a difficult issue, whether it's broad or narrow. The difficult issue we have here that we have to focus on, that we have to answer today, is pending cases invoices. Not at the end of the day, not when the case is ended. I mean, if this was a case where the 3 requests were made, for invoices on the completed cases and LA County refused, and we were here, not going to look pretty good for you. Just sounds like it doesn't look good. But we're not looking at that case. We're looking at pending cases. And so I want to ask you about pending cases. If this rule were to be adopted, if we adopted the rule that invoices were permitted to be discoverable or part of the Public Records Act in this situation under the Public Records Act and the Evidence Code, would this rule also apply then to criminal cases, say involving death penalty requests? As we know in that situation, we permit the attorney representing the accused to go to a trial judge privately, ex parte, and obtain funding to investigate the death case. So it seems to me if we write this rule, that it would be applicable then to the situation where there's a public records request of the county or of the court to disclose what it is defense counsel is requesting for investigating and defending the death case. Would this rule also be applicable to that situation?
I think it would be an interpretation of the evidence code, and yes, I mean, I do think that's correct. And the fact that this is a pending case, from our point of view, really just underscores why this kind of information does impact litigation decisions. That it's not just sitting in a vacuum as financial information or sitting in a vacuum as just factual information about a case as opposed to advice or an opinion. It is something that clients expect. It's something that affects the way the lawyer performs, and it affects the way the client makes litigation decisions. And so I think the fact that these are pending cases just underscores why this kind of information falls within the attorney-client privilege. And I think, again, we talk so much about there's a broad interest in the public's right to know. That's correct. But the statute does recognize the attorney-client privilege, and this court held in Roberts v. City of Palmdale that a public entity has the same right to the attorney-client privilege as an individual. And I think what we're often hearing from real parties in interest is that I think they don't like the way that client has been defined, is that they want greater public input into litigation-type decisions. Well, that's something that you trust to your public officials, and if you don't think they're doing a good job, and that job might include, to address Justice Cuellar's inquiry, if they're not turning over information about pending cases to your satisfaction or closed cases, you vote the rascals out. I mean, that's how the political system works. But you don't narrowly construe the attorney-client privilege with respect to information that everybody seems to kind of agree is directly relevant to talking about how a case is being litigated and what kind of decisions are being made by the client.
If we agree with you with respect to pending cases, do you see any limit to that theory for completed cases?
I think would be the same rationale.
Broader, but
no,
I want to know what we're sort of buying into if we agree with you.
I think it does, because the privilege does go beyond pending cases. That's how the attorney-client privilege is. I think, again, as I've mentioned, the fact that this involves pending cases, I think it puts in sharper relief why that kind of information is directly connected to the attorney-client relationship and in furtherance of the attorney-client relationship. It brings it in sharp relief when you can look at it today. But that's sufficient to establish the privilege, but the privilege survives beyond the pending litigation. And I will note that I find my friends across the aisle taking a different position now about the pending litigation exception to the PRA, because they've always said before, they cite the Anderson-Barker case, that doesn't apply. And now they say, well, that would be the best place to apply it, but it doesn't apply to these type of invoices. And so what they're basically saying is they want unfettered access to these invoices, including information, factual information, that I think falls squarely within what this court in Mitchell said would be attorney-client communications. And what they're suggesting is that you have judges review these redacted documents, and that's exactly what this court said judges cannot do in Costco.
Tell us in a nutshell, counsel, what you think Sections 954 and 952 mean. What is the scope of the privilege?
Scope of the privilege is a confidential communication between the attorney and the client in furtherance of the attorney-client relationship. That's, and by attorney-client relationship defined as it has been in the context of the attorney acting as an attorney and not doing something else like being a witness or being a broker or something of that nature.
Because as we said in Costco, that cannot mean that an attorney can simply make something privileged by transmitting it confidentially to the client in the course of is crucial here. So what meaning do you give that?
In course of is the attorney, it's in the course of a relationship in which the attorney is representing the client, not as an attorney, not as a broker, not as a witness, and that's the distinction that was made in the legislative history. It's the distinction that Chief Justice George made in his concurring opinion in Costco. When you're not acting as an attorney, it's not an attorney-client privileged communication, but there is no dispute here that these invoices were sent between the county attorneys and the county with the attorneys acting as county attorneys. That's the whole point of the request. So if the court has anything further, otherwise, I'll submit.
Thank you, Mr. Coates.
Responding initially to the first point, I would ask, I mentioned before Salone, 39 Cal 2nd at 79 to 80. That was a case in which the lawyer was specifically acting as a lawyer in connection with cemetery plots. And in the course of the discussion regarding the cemetery plots, the lawyer and the client also discussed the other disposition of the property. And the court distinguished, even though the lawyer was acting in the course of the relationship as it related to the cemetery plots, the court held that the other information about what the testator was going to do with the rest of his property was not privileged. And so the court really looked at the particular communication and not just the broad matter and not just the broad communication, really the specific thing being addressed or being exchanged. I'd like to pick up on the point made by Justice Cuellar regarding the segregation mandate in the CPRA, 6253A. And we think that, if nothing else, that should lead to the decision that we're asking this court to enter, because the court has to harmonize the attorney-client privilege and that segregation mandate. If there is a conflict, we don't think that there is a conflict, but if it's the court's conclusion that the attorney-client privilege completely exempts the invoices, there's no reason that Evidence Code Section 952 should prevail over the segregation mandate in the CPRA. And under the Constitution, the court is required to adopt the more narrow interpretation that would give the public the most information.
Can I ask you, the rule you assert today, would it apply in criminal law?
Your Honor, I believe that the attorney-client privilege, as it is interpreted by this court, is interpreted across all laws, and so it would apply in criminal law. I'm not familiar with the rule that the court alluded to, but I would point out that while this case arose in the context of appending cases, the rule that they're asking for, as they concede, would apply to closed cases, and it would really shut down.
But isn't the example that the Chief Justice gave regarding the information from defense counsel in capital cases problematic?
I apologize, Your Honor. I'm not familiar enough with that rule to have followed that example. And so
one of the problems we have when we write a rule, we have to be mindful of the law of unintended consequences, and that's why we're asking you about this.
Absolutely, and I completely appreciate that. And that's the reason I refer to the closed cases, and also the reason that our brief talks so much about fee motion jurisprudence, because it really would wreak havoc in that if the client had absolute control over the invoices and could decide whether or not the invoices would be submitted, if the trial court had no discretion.
The theory behind these privileges is that they exist to protect people in certain contexts, whether it's physician-patient or priest-penitent or any of the other privileges. They are a social statement about the need to protect people generally seeking assistance of some kind.
But that begs the question of whether or not the privilege applies. And, it is certainly the fact that throughout the many decades of this court's fee motion jurisprudence, the courts have treated invoices as if they are evidence, basically, and they have asked for better evidence whenever they needed it. If the court took away the trial court's discretion to demand invoices in a case where $2 million in fees are sought, it would really hamper the trial courts in a way that would...
Before you run out of time, let me ask you one question that was raised by your friend on the other side. He said if it were up to him and he were redacting these invoices, he would cross out everything except the final amount.
And we think that that would be probably overstating it, perhaps in the context of pending litigation.
Isn't that what you want?
to cross out everything
No,
except...
isn't that the objective? You want to know the final amount that they spent on X?
That is one objective. We certainly want that at a minimum, but we think that there's a public interest in giving broader information as it relates to pending cases, but certainly as it relates to closed cases. And I see that I am over my time, and so I thank the court.
Thank you, Ms. Wilcox. Thank you, Mr. Coates. The matter is submitted. We stand in recess.
All rise. Court is now adjourned.